41 seconds. On September 4th at 10:22 in the morning, Colt Gray opened fire in Apalachee High School for 41 seconds. Those 41 seconds forever altered the lives of the students of Apalachee High School, their parents, and everyone in this community. At 10:22 a.m., Christian acted and became a hero. He attempted to push the shooter out of his classroom, and when he was shot, Christian's last act on this earth was to shut the door to his classroom to protect his friends. In Miss Ryan's room, the teachers and students acted. Ronaldo ensured the door was barricaded, and Landon held Taylor's hand when she needed someone. Ariana tried to keep Taylor awake, and Miss Ryan attempted to put a tourniquet on Natalie's arm and comforted her. Miss Irmy acted. Her last act on this earth was to push her door shut to protect her students. When the shooting started, Coach Aspinwall acted. He went outside his classroom to see if he could help. Coach Phoenix acted. After being shot, he crawled back into his room and used his last bit of strength to shut his classroom door to protect his students. Valerie Lancaster acted. She used her training from Girl Scouts and stopped the bleed to save Coach Phoenix's life. And Sweet Mason, he didn't even have the opportunity to act. On September 4th at 10:22 a.m., SRO Donovan Boyd yelled into his radio, "Active shooter."
Active shooter. Active shooter. What? Active shooter at Apalachee High School.
And at that moment, every law enforcement in Barrow County and every law enforcement officer near Barrow County acted. 58 agencies and 400 law enforcement officers came to Barrow County to answer the call for help. Within a minute of hearing those first shots, SROs Boyd and King took the shooter into custody and saved Zane Zinni's life. He was in that last hallway seconds from being shot by Colt Gray. Sheriff Judd Smith and Lieutenant Wilkerson acted. Sheriff Smith was one of the first responders and helped get Natalie to EMS quickly, and Lieutenant Wilkerson did everything he could to save Miss Irmy's life. And the incredibly quick response by EMS and law enforcement saved the lives of Coach Phoenix, Natalie, Taylor, and Melanie. Ladies and gentlemen, at the end of those 41 seconds, the sense of security that this school and this community once had was shattered. But also in the aftermath of those 41 seconds, a community united, heroes emerged. Parents from all backgrounds came together on the football field to try and find and embrace their children. And every person in this community wanted to know one thing: who did this and how did this happen? Everyone except for that man, the defendant Colin Gray. He was not asking that question because he knew exactly who had done this and how this happened.
God. I knew it when my little girl just texted me. She's in middle school. She said, "We're in lockdown." I'm like, "God almighty, please tell me your brother did me something."
Why do you?
In fact, that man was the one person who could have prevented this mass shooting. He was the one man who ensured that Colt Gray had the tools he needed to commit mass murder. Ladies and gentlemen, that man and his son are both responsible for the immense suffering that occurred on September 4th. The blood is on their hands, and the defendant needs to be held accountable for his actions that led to the murder of 4 people and numerous other injuries, both mental and physical. I know this case has had testimony that was difficult and upsetting to hear, but I want to thank you again for your service as jurors. I have 2 opportunities to speak to you, like Judge Prim just said. After defense counsel gives their closing argument, I'll come back before you and explain why the evidence has proven the defendant guilty beyond a reasonable doubt. So right now, I'm going to briefly go over some of the law that the judge is going to give you to help you put some of the evidence in context. One thing he's going to talk to you about is the elements of the crimes that the state has to prove beyond a reasonable doubt. The defendant is charged with 29 crimes in the indictment. All of these crimes were committed in Bexar County. Apalachee High School is in Bexar County. The defendant's house, where he gave Colt access to the rifle and ammunition, is in Bexar County. So the first charge we're going to talk about is murder in the second degree. The defendant is charged with 2 counts of murder in the second degree for Mason and Christian, because they were the 2 children that were killed. To prove this, the state must show that the defendant caused the death of another human being, irrespective of malice, by committing the offense of cruelty to children in the second degree. When a child dies during the commission of cruelty to children in the second degree, then that is murder in the second degree. This is not malice murder. That's a completely different crime. No malice is required for second degree murder. And that means that a defendant did not have to intend for Christian or Mason to die. The state, however, does have to prove that the defendant's actions were the proximate cause of these deaths. And that is that his actions played a substantial part in bringing about or actually causing the deaths, and the deaths were reasonably foreseeable. For the first prong, at the age of 14, Colt could not legally buy a rifle or ammunition. He was too young. He also was too young to even drive to buy a firearm illegally. But for the defendant providing his son with a rifle and ammunition, these deaths would not have occurred. If you find the defendant guilty of cruelty to children related to Mason and Christian, then you have necessarily found that the defendant's actions played a substantial part in causing their deaths. As far as reasonably foreseeable, the state has to prove that these deaths weren't a remote possibility, but something a reasonable person could see happening. I like analogies, so I'm going to use a few throughout this closing. It's not to be flippant, but it's to try to explain the legal wording in a context that's relevant or more easily to understand. So here's my first one. Think about road signs, like the one that warns of falling rocks from a cliff. If you drive by that sign, you may not know exactly when or what type of rock is going to hit you, but you're on notice that if you drive by a cliff, you might get hit by a rock. Warning signs make something reasonably foreseeable. And ladies and gentlemen, we'll go through all this evidence in the second closing, but there were months and months and years of warning signs leading up to September 4th. Any reasonable parent, any reasonable person would have foreseen that Colt would harm somebody. Even 13-year-old Jenny Gray saw this coming. Jenny told the defendant, "But I think we are thinking the same thing, and I don't want to talk about it over text." And the defendant's response was 10-4, because he certainly saw this coming too. He is guilty of these charges. Next, we have 20 counts of cruelty to children in the second degree. To prove this charge, the state has to prove that the defendant caused cruel or excessive physical or mental pain to a child under the age of 18 years through criminal negligence. For the first element, the defendant caused this pain by consciously disregarding a substantial and unjustifiable risk that his act of allowing Colt Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition, after receiving sufficient warning that Colt Gray would harm and endanger the bodily safety of another. And thereafter, Colt Gray did shoot at and shoot children. That's what is in the indictment, and I know it's lengthy, but that is what the state has to prove. So to break this down a little, I want to first talk about the act that the defendant committed. The defendant gave access to a semi-automatic rifle and ammunition to his son, Colt. His son, who was a minor over whom he had custodial responsibility. Now, Colt lives in the defendant's house. The defendant bought him the rifle. The defendant had the ability to take that rifle away if he wanted to. The defendant gave this access to Colt after he received sufficient warning that Colt Gray would harm and endanger the bodily safety of another. Now, the defense in opening misled you about this part of the law. They said we had to prove that the defendant unequivocally knew that Colt would harm someone. This is not what the law is. This is what they want the law to be. But what the indictment says, what the law says, is that we have to prove the defendant received sufficient warning that Colt would harm someone. Sufficient warning. Here's another analogy. If you see a weather report saying there was a 70% chance of rain, then you've received sufficient warning that it would rain, and it's your responsibility to bring an umbrella. When looking at the evidence in this case and deciding this case, keep in mind what the actual law is and what the state has to prove. Listen to the judge as he charges you on the law. Remember, it is you, the jury, who decides what is sufficient warning. And you've heard the evidence, and you know that the defendant was sufficiently warned that his child would hurt someone. I also want to point out that the judge is going to instruct you that when a count on the indictment charges that the defendant committed a crime in more than one way, you may convict him if the evidence shows that the crime was committed in any of the ways on the indictment. Essentially, what that means is if there is an and in the indictment, it means or. So, for example, in cruelty to children, we charge would harm and endanger the bodily safety of another. But all the state has to prove is that it would be would harm or endanger the bodily safety of another, not both. So if we prove one, then the defendant is guilty of that charge. And that goes for any time there is an and in the indictment. It means or. When the defendant gave Colt this access to a firearm and ammunition, he consciously disregarded a substantial and unjustifiable risk that Colt would hurt someone. The term conscious disregard is defined as rising to the level of a gross deviation from the standard of care a reasonable person would exercise in this situation. And finally, the harm, as we know, occurred when Colt shot at and shot children at Apalachee High School. That's the first element of cause for cruelty to children. The second element is cruel or excessive physical or mental pain. The state has to prove that each of the victims listed in the indictment suffered cruel or excessive mental or physical pain. I know those kids' testimonies were heart-wrenching and difficult to listen to, but we had to call them to testify in order to prove this element. Each and every one of them had cruel and excessive physical or mental pain. You have Taylor, who still walks with a limp, has had countless surgeries, sleep terrors, and anxiety. Natalie does not have full use of her hand and has PTSD. Melanie took 6 months to recover, missed her soccer season, and still has images of that day stuck in her head. Nautica can no longer play sports. She had nightmares and thoughts of suicide. Jackson has been unable to go back to school because of what happened, and he had to give up something he loved, the marching band. Ronaldo became more aggressive, had bad dreams, and could not hug his own mother. Hayden has panic attacks and lives in fear that this will happen again. William sent his family a text message after the shooting telling them he loved them and that he thought he was going to die. Kendez has nightmares and spent a year and a half believing that he had left the door to his classroom open. Marquez constantly thinks about what happened that day and has even lost his love of sports. Brittany is scared easily and is triggered by loud noises. Michaela is traumatized and is scared to stay home alone. Jalen has more anxiety, and Martin is constantly looking at doors, afraid of what might happen. Ariana started anxiety medication and has intrusive thoughts of Christian. The second element is met. And of course, for the third element, you heard either the students or Ms. Ryan testify that they were all under the age of 18. The final element for cruelty to children in the second degree is criminal negligence. That is defined as an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured. The defendant is not charged, again, with purposely or intentionally bringing about the harm, but with recklessly doing it. And reckless disregard for the safety of others describes exactly the defendant's actions in this case. So those are the two charges that are related to the child victims. The next two charges we have are related to the adult victims. That is involuntary manslaughter and reckless conduct. The first charge we're going to talk about is involuntary manslaughter, which is the corresponding charge for adults for murder in the second degree. The defendant is charged with 2 counts of this against Coach Aspinwall and Miss Irami. In order to prove involuntary manslaughter, the state has to prove that the defendant caused the death of another person without intending to do so by committing the offense of reckless conduct. Again, the defendant did not have to intend to kill these people, but if someone dies during the commission of reckless conduct, then that is involuntary manslaughter. For all of the adult victims, there's also a charge of reckless conduct. And again, this is the corresponding charge to cruelty to children when the victim is an adult and not a child. And it is laid out the exact same way as the cruelty to children charges. In order to prove these counts, the state has to prove that the defendant caused bodily harm or endangered the personal safety of another by consciously disregarding a substantial and unjustifiable risk that the defendant's act or failure to act would cause harm or endanger the bodily safety of another. And clearly the defendant's actions in this case constitute reckless conduct. Before I move on from discussing the charges, I need to talk to you about something called lesser included charges. What that means is the defendant is going to ask you to either find him not guilty or find him guilty of only a lesser charge. He wants you to do exactly what he does every time he talks. Make his actions seem better than they actually were. On this verdict form, which you'll have with you back in the jury room, it'll have what the state indicted the defendant at the top, and then under it, it'll be the 2 lesser included charges for murder, and then there'll be 1 lesser included for involuntary manslaughter. I'm going to start with the first lesser included for murder in the second degree. For that one, the defendant wants you to find him guilty of only the lesser included charge of involuntary manslaughter, like we just talked about for the adult victims. He wants you to find that Mason and Christian died in the commission of a reckless conduct instead of a cruelty to children in the second degree. The only way you can find this lesser charge is if you find that Mason and Christian did not suffer cruel or excessive pain. Since Mason and Christian are under the age of 18, that's the only additional element that separates cruelty to children from reckless conduct. To find that Mason and Christian did not suffer cruel and excessive pain, you would have to put aside all logic and common sense. These children paid the ultimate price for the defendant's actions, and there is no argument that their pain wasn't both cruel and excessive. Ladies and gentlemen, when you go back to the jury room, read the indicted charge. Read what murder in the second degree is on the indictment. If you find him guilty of that charge, leave the other 2 blank. And remember, if you find the defendant guilty of cruelty to children in the second degree because Mason and Christian died during that act, that man is guilty of murder in the second degree. The law is that simple. For involuntary manslaughter, the defendant is also asking that you find him guilty of the lesser included charge of involuntary manslaughter lawful act. What he is charged with currently on the indictment is involuntary manslaughter, unlawful act. This is also going to be a second lesser included of murder. So for second degree murder, it'll have involuntary manslaughter, unlawful act, and involuntary manslaughter, lawful act. And then for involuntary manslaughter, it is going to say the indicted charge is unlawful act, and the lesser included is lawful act. The judge is going to instruct you that this version of involuntary manslaughter means that someone dies in the commission of a lawful act in an unlawful manner. An example of a lawful act in an unlawful manner is building a porch without a permit. It's lawful to build a porch. It's unlawful to do it without a permit. Ladies and gentlemen, what this man did is not the equivalent of not getting a permit. This man in no way committed a lawful act. Buying a gun for the purpose of transferring it to your 13-year-old child is illegal. A reasonable gun owner would secure his weapons just because he had children. It is certainly a gross deviation from that standard for the defendant to let a child like Colt Gray have a rifle in his room. For the adult victims, find the defendant guilty of the indicted charge of involuntary manslaughter, unlawful act, and leave lawful act blank. And for the child victims, again, find him guilty of murder in the second degree and leave the other two blank. Essentially, the defendant wants you to convict him only of something that is barely a crime because it was committed doing a lawful act. Don't let these lesser included charges confuse you. The defendant is guilty of what is charged in the indictment. The defense claimed in opening statements that if you find the defendant guilty, it's a slippery slope, and parents will start getting charged all over the place for crimes their children committed. Ladies and gentlemen, the defendant is not charged with these crimes because he is Colt's parent, because he shares his last name. He is charged with these crimes because he shares the blame. Think about it this way. Our children do risky things all the time. For example, a 16-year-old driving a car is inherently risky, but parents let their children drive because it's a justifiable risk. A parent does not commit a crime if their 16-year-old gets in a car accident and kills somebody. However, if you give your 16-year-old a six-pack of beer, watch him drink it, see him fall over the place, help him up, then him driving, now that's become an unjustifiable risk. If you disregard that risk and give your child the keys to the car and watch him drive off, and then he kills someone, then yes, your actions combined with your knowledge are criminally negligent and they're reckless, and you're guilty of murder in the second degree or involuntary manslaughter, depending on the age of the victim. But that's because of the parent's own actions, not just because their child did something. After seeing sign after sign of his son's deteriorating mental state, his violence, his school shooter obsession, the defendant has sufficient warning that his son was a bomb just waiting to go off. And instead of disarming him, he gave him the detonator. Charging the defendant is not a slippery slope. It's reasonable, it's common sense, it's justice. The last part of the law I'm going to go over with you is reasonable doubt. The judge is going to tell you that the state has the burden to prove all the elements charged in the indictment beyond a reasonable doubt. Reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. When you seek the truth, you do not abandon your common sense. Use your common sense when you are deciding this case. Think about it like this. In Wheel of Fortune, there's a moment where contestants know exactly what the phrase is, even if all the letters are missing. The moment you know that the defendant is guilty, even if there are some missing letters, that is the moment that you have found beyond a reasonable doubt. Now, the defense attorney is going to get up here and do his job and try to convince you to acquit the defendant. Then I'll come back before you and do my job and explain why the evidence has proven him guilty beyond a reasonable doubt of all the charges. And as you listen to these final two closings, keep in mind what your job is. Your job is not to look for doubt. Your job is to honestly seek the truth. And in this case, if you look for the truth, you will find that there is no doubt that the defendant is guilty of all charges.